And finally, speaking of the January 6th committee, Alex Jones has decided to sue the January 6th committee and, of course, AT&T to stop the release of his phone records to that committee. Now, his argument, little interesting. Let's hear it here. It says, quote, in the lawsuit, a declaratory judgment that the subpoena to Alex Jones and the subpoena to AT&T serve no valid legislative purposes and exceed the select committee's and Congress's constitutional authority in violation of the separation of powers principle contained in the United States Constitution. Now, if you'd have stopped before you got to the separation of powers, you actually had what's not considered to be a terrible legal argument. The separation of powers has nothing to do with what you're talking about, though. So you kind of overstepped there. But let's get to this, right? The constitutional basis for the House of Representatives, a committee in the House of Representatives to carry out these investigations. Believe it or not, is that included in the Constitution? No. No, it's not. That's something a lot of people do not know. But the Constitution does not say specifically, explicitly, that the House of Representatives gets to carry out these investigations. However, precedent tells us otherwise. Court cases, Supreme Court cases, tell us otherwise, because the Supreme Court, for several hundred years now, has interpreted the Constitution to basically say that the founders intended for Congress to have this power. Because, all other duties. That's actually what they cite. So the courts have told us Congress does have this authority, even if it's not always for a specific legislative purpose. And for the record, the history buffs out there, you may already know this. This goes back to 1795, when Congress conducted its first investigatory action, really. Happened all throughout the 18th century, the 19th century, the 20th century, and of course all the way to today, and court cases all along the way reaffirmed Congress's authority to actually do this. So if you were going by the strict letter of the law in the U.S. Constitution, this legal argument is actually not that absurd, which, a little disappointing. But when you look at past court precedent, when you look at the precedent that Congress itself has set, the powers that they have won in these court cases, then they absolutely have the authority to do this, even if it's not for an explicitly legislative purpose. Now, that may be the only thing, because that's still considered a very legal or a very gray area in the legal world. That may do something to move the needle a little bit, but I seriously doubt it. Courts have already ruled, obviously, in this particular matter, not necessarily with Alex Jones, but in Trump trying to claim executive privilege from other committees also saying, you can't have my financial documents because it's not for a legislative purpose. Courts have said, we don't care. That doesn't matter. It doesn't have to be. Again, Constitution's iffy on this. It's going to depend on what kind of judge it goes up against. But of course, Alex Jones, if he was in communication with these individuals inside the White House on the day of the riot, obviously would be a person of interest, which would make it a valid subpoena if, of course, Congress does have the authority to even conduct these investigations, which is why, as I continuously say, the committee needs to turn their documents and everything they have over to a special prosecutor and let the DOJ take it from here. You avoid questions like this, you avoid some issues, everybody's a winner. We got some great content coming up for you in the bonus show. I'm Farron Cousins, been sitting in for David Packman today. You can find me on Twitter, Facebook, Instagram at FarronBalanced, rofpodcast.com. Thanks for watching, and I'll see you tomorrow.